Florida is officially a constitutional carry state. This grants most citizens the right to carry a concealed firearm or concealed weapon on their person. Thank you to Governor DeSantis, thank you to the state legislature, and thank you to nonprofit organizations such as Florida Carry who've remained on the front line of this fight. In this video, we're going to review the requirements and limitations of this law in 5 minutes or less. Are you one of the 2.5 million Florida concealed carry permit holders? If so, there's only one minor change to this law. It's really inconsequential. You no longer have to carry your Florida concealed carry permit with you. All you have to carry is your valid ID. Florida is now touted as a constitutional carry state, but the term constitutional carry has different meanings depending on who you're speaking to. As it relates to how Florida law was, you couldn't carry a concealed weapon or a concealed firearm unless you had a concealed carry permit. Now the law is everyone, regardless of whether you have a permit, can carry a concealed firearm so long as you don't have one of these disqualifying circumstances. You don't meet the minimum age requirements. You're not a resident of the United States. You have a felony conviction or domestic violence conviction. You're disqualified based upon recent criminal history. You're not of sound mind. There's an active injunction or restraining order. Some people are refusing to call Florida a constitutional carry state because the law imposes restrictions upon who can carry and limitations on where people can carry. Instead, they've been using the term permitless carry state. Given what you now know, do you consider Florida a permitless carry state or a constitutional carry state? Let me know down in the comments. Florida has been and remains a shall issue state. This means the state of Florida is required to give you your concealed carry permit if you meet the qualifications. That hasn't changed. In addition to shall issue, we are also now a permitless carry state. To determine who's not eligible to carry, we have to look to Florida State Statute 790.01, the carrying of concealed weapons or concealed firearms. A person is authorized to carry a concealed weapon or concealed firearm if they're licensed, or if they're not licensed, but they otherwise meet the criteria for obtaining a license. If you've never been arrested, you've never had an injunction served against you, you're mentally sound, you're a resident of the United States, and you're over the age of 21, you shouldn't have any problems. For the rest of us, though, you're going to want to dive deeper into this law to verify that you're good. You don't want to get a felony. If you've got baggage in your background and you want to confirm that you're eligible, probably the best way to do that is to actually apply for a concealed carry permit. Costs you $100. Once you pass the background check, you'll know that all of your background information is sufficient to the year to date of the application that you're going to meet the requirement. I do want to discuss some of the criminal history restrictions. So let's turn to Florida Statute 790.06. Withhold adjudication on any felony must wait 3 years. Withhold adjudication on domestic violence must wait 3 years, not otherwise prohibited by federal or Florida law. Subsection 3 has 3 parts that are all lumped together. I'm going to break it down for ease. The first part has to do with misdemeanor crimes of violence. If you've been adjudicated guilty, a withhold of adjudication, or had a suspended sentence for any misdemeanor crime of violence, you can't permitless carry under this statute until 3 years have elapsed after you completed all the court requirements. This is what gets people, because if you have an open fine or fee, that's not complete. You can also have your record sealed or expunged. That'll take care of it as well. Part 2, if you were arrested or charged with an offense that would disqualify you if you were convicted, then you can't carry while that charge is pending. The third part, if you're served with an injunction, you can no longer carry a firearm under this statute. Violating this statute by carrying a concealed weapon results in a misdemeanor of the first degree, punishable by a year in jail or a $500 fine. If you carry a firearm, that bumps up to 5 years in prison and a $5,000 fine. In order to find you guilty, the state of Florida has to prove that you didn't have a concealed carry permit and that you didn't qualify under the statutes. So we just reviewed 790.01, which was modified as of July 1st, but now we have to look to 790.013, which is actually created. This new law regulates the concealed carry of firearms by people without a concealed carry permit. The law requires that a person carrying a concealed weapon or firearm always be carrying some type of valid identification. And then in addition to that, you're required to present your identification to the law enforcement officer upon their demand. There's no mention of notification requirements, but you are required to provide the ID. Subsection 2, a person is subject to the limitations imposed by 790.06 subsection 12 to the same extent that a person with a concealed carry permit holder would be subjected to. Let's turn to that. 790.06 subsection 12A regulates where people cannot carry a firearm. Let's go through that list quickly. Any place of nuisance, any police station, any jail, courthouse, polling place, any school, college, or professional athletic event not related to firearms, any school facility, any career center, any portion of an establishment licensed to dispense alcoholic beverages for the purposes of consumption on the premises, of which portion of the establishment is primarily devoted to that purpose. In the airport, provided that no person shall be prohibited from carrying a legal firearm into the terminal, which firearm is encased for shipment for purposes of checking such firearm as baggage, or any place where the carrying of firearms is prohibited by federal law. Any such person who knowingly and willfully violates this provisional law commits a misdemeanor of the second degree, punishable by 60 days in jail and a $500 fine. Guess which one of these I may have violated here recently and got caught? Since we're in subsection 12, let's jump down a notch and look at subsection 13, which is a special rule for concealed carry permit holders and churches. Question is, if you're a concealed carry permit holder, you're allowed to carry in church. What if you're a church and you're inside of a school? Or what if you're a church and you have a school inside the church? Can you carry? Let's look at the statute. Subsection 13, notwithstanding any other law, so it doesn't matter what anything else says, for the purposes of safety or any other lawful purpose, a person with a concealed carry permit license may carry a concealed weapon or concealed firearm on property owned, rented, leased by a church or other religious institution. This subsection does not limit the church from imposing their own restrictions on their private property rights. I read that as it goes both ways. If your church has a school within it, you're good. If your church is within a school, you're good. That leaves two things for us to discuss. The first being the concealed carry of firearms inside your vehicle. The language of the law was modified, but it's mostly cosmetic in nature. The substance of your rights to carry securely encased inside your vehicle remains the same. I've included a link to that law as well as a Dropbox folder with other useful information down in the description of this video. The last thing we have to discuss is how to interact respectfully with a police officer without folding over on your constitutional rights. Both of these are critical topics that you need to pay attention to, but they're outside the scope of this video. Check out the videos on the screen. Have you subscribed yet? Did you at least like the video?